I'd like to offer my strong support for this amendment offered by the gentleman from Kentucky and co-sponsored by Democrat colleagues and with support from other Democrat colleagues. I think it's much more important than we think. And to the gentleman from Wisconsin's point about reports, I'm no fan of our frequent go to the floor and offer some reports as basically cover for doing something, okay? I'm not a big fan of that. In the context of very specific purposes, to ensure oversight on executive branch in protection of civil liberties and our constitutional rights, regardless of one's political views, it's hard to be over-demanding in forcing reports out of the executive branch for how they're carrying out their authority, particularly in this context, particularly where the broad authorities of the executive branch with respect to foreign engagement, national security, where there is a great deal of power in the executive branch under the Constitution. This is the area where I would say is maybe the most important for critical congressional oversight. And I want to add another context to this because I think there's going to be another amendment coming up shortly that I'm offering that requires monthly reporting in my amendment, and there's some debate back and forth about whether that's too burdensome, and we'll talk about that in a minute. But the context here I think matters. We are putting in our bill a warrant requirement, right, with respect to U.S. persons being queried in a 702 database. We are doing that over the objections of the intel community, both members of this body predisposed in that direction, as well as the intel organizations themselves. We are doing that because we are expressing our interest as Congress that we put that additional layer of protection in place to protect civil liberties. Given the exchange had yesterday with Senator Lee and FBI Director Christopher Wray, in which Senator Lee highlighted the extent to which it was reported in the PCLOB reports on civil liberties, the extent to which, and I'm quoting, particularly troubling is that the FBI has never once submitted an application to the FISC pursuant to Section 702 F2 in which the warrant requirement actually applied. That's an actual problem where under our current laws, a warrant requirement is in place and the executive branch is plainly ignoring it. On page 188 of the report that I'm looking at, which I've asked to be submitted to the record by the PCLOB.
Without objection.
You see in 2018, 2019, 2020, 2021, and 2022, a total of 103 examples of cases where the reports to the FISC as required by court orders that we didn't actually have the warrants being submitted, and that's a problem. And so I think these reports, like the gentleman from Kentucky are offering, are critically important for Congress to assess whether or not the executive branch is following the law. In a moment, I'll be offering an amendment to make a very narrow section of the reporting requirements, that is, how many warrants are being offered, how many queries have been hitting a database on U.S. persons. I want that on a monthly basis. I'll be honest with you, and I'll talk about that more in a minute. I want it on a minute-by-minute basis, but that might be cumbersome. The point here is—
The gentleman yield. The gentleman yield.
I'll yield, sure.
I just want to say that, as you may recall, last time we reauthorized the bill, we got rolled by the Intel Committee.
Yeah.
And their warrant requirement was designed not to be enforced.
Correct.
In the bill that we have before us,
I agree.
We have very good enforcement mechanisms.
And I thank the gentleman for that. And I agree that the enforcement requirements in this make it more likely that they will be followed. But let's just say my trust level is not high.
Well,
and so my perspective here is that to a degree, we are punting our responsibility to Article 3. We are punting our responsibility to the FISC. And I don't mean that as a negative. I'm just saying, let me rephrase that to say we are over-relying on Article 3 and the FISC court. And I want to increase the reliance on Article 1, review of what's going on. Understanding that the amicus curiae, understanding that some other provisions we put in there insert us more into it. I want every member of Congress to be able to basically have alarm bells going off. So we'll get into that amendment in a minute, but I strongly support this amendment on an annual basis, providing more granular detail, and I yield back.
Gentleman yields back for purposes. Gentlelady from Indiana seek recognition.
I move to strike the last word.
Gentlelady's recognized for 5 minutes.
Thank you. I appreciate Representative Massey doing this amendment, and I really like the rationale. Maybe they don't have much time then to harass Americans. So I really like that. I think one thing, and I will address one in my amendment a little bit later on, we have a lot of reporting, which is great, but we really don't have a system for us to look at these reports, and it's very hard to find these reports and take action. So we also need to think about it, how we can not just look once every 5 years at these reports when we do reauthorization, but how we can have more timely responses and set up Congress to deal with this. So I think it's very important to have a separate person also doing this report, but we need to think that maybe these people, we should have a specific hearings where these reports will be discussed and presented, and we can do that, but maybe we need to start mandating some of these hearings, which will force us to look at these reports, because if you look at the PCLOB report, that is very alarming. A lot of recommendations and a lot of conclusions as they reach by reviewing this, and how many rights of Americans been violated. We turn into a surveillance state. So I am very much supportive of this. I think it's very good to have additional reports, and hopefully it will force some of the people in the intelligence community to think twice, maybe, before they decide to do these queries, because they decide to do these procedures, because they've been taken very lightly and been abused significantly. And I think, we are turning into being a police and surveillance state, which is very, very dangerous. And I am very happy to see we have a support on the bipartisan basis, because this issue shouldn't be partisan. We have a lot of partisan issues, but I appreciate that actually people on the left and on the right can agree on some issues, and and we don't have to go very far in amendments. We actually can agree on the force. So I certainly support this amendment.
Will the gentlelady yield?
Yes.
I just like to add that the importance of reports is not just who might read them, but their influence on those who write them. It's a reminder that there is oversight, however imperfect, and it puts them on notice that at any given time that agency may be called to account for the activities that it is reporting, and that is a very good thing. I yield back.
Yeah, thank you. I completely agree with you, and I yield back.
Gentlelady yields. Anyone seek recognition? Question occurs on the amendment from the gentleman from Kentucky. All those in favor say aye. Aye. All those opposed, no. Opinion of the chair is the ayes have it. The amendment is adopted. Who seeks recognition? Gentleman from Texas.
I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 6570.
Without objection, the amendment will be considered as read. The gentleman from Arizona reserves a point of order, and the gentleman from Texas is recognized.
Thank the chairman, and I may not need to use the entire 5 minutes because I laid the foundation in the context of the previous amendment, which I wholly support. That amendment has a much more granular and more detailed requirement of information that is required to be presented to Congress on an annual basis. That is a very good thing. It allows us to analyze what's actually happening.
Are you guys comfortable with
the one thing that I think is important here is, while I agree with what the ranking member said about the civil penalties and the criminal penalties being in this bill and other provisions that are likely to encourage a greater adherence to the requirements, which have been ignored, right? As I pointed out in the exchange between Senator Mike Lee and Christopher Wray yesterday over in the Senate, literal warrant requirements being just blatantly ignored. My concern here is, depending on what happens here and in the Intel Committee and the floor in the Senate, with 12-333 in executive orders, with the possibility always of a rubber stamping of warrants, which could end up being the case, or the ignoring of the requirements in some form or fashion, we don't know how our best efforts here will play out, right? We're drafting something that likely we won't readdress for another 5 years. There's a reason we're doing this right now. It's because we have to. And so my point is, and I was trying to allude to it before, we in Congress need to be more actively engaged in this particular question, because it's a fundamental duty for us to check the executive branch. And I understand there's provisions in here, like I said, with the amicus curiae. There's provisions, for us to have 2 members, at the designation of the chairman in the room as needed, and staff. That's good. But we know how this place works. We know how this town works. We know how busy everybody gets. We know how busy members are. Staff who end up in the room can often end up getting sucked into the vortex of the mood in the room to go after bad actors and to say, you want to go do this, right? Those of us who've been prosecutors have seen that, where you get into that mentality. All I want here is a minimal amount of information on a more regular basis. Like I said, I'd like to have my phone chime every single time a U.S. query is made, right? And I can go, why the hell is that going on? Now, that's a little absurd. That might be a little much. I guess my point is, psychologically speaking, that's where my head is. So to me, a monthly report on this very minimal subset of information about whether warrants have been carried out, or whether or not the number of queries, is just a way that we get it in January or February or March. We're just not waiting for an annual basis to say, hey, what the hell are you guys doing? Right? Are you implementing this? And I know there's going to be some pushback on the burden. Come on. They're going to be collecting the data to report it annually. I think having that same staffer who's going around collecting it, going around to the U.S. courts and talking to the FISC judges and whatever, however that will happen, we can all figure that out. You collect the information and then you report it to us on a monthly basis. And then our staffers in the room and our appointed members in the room now have more information. And frankly, we, the general members, now have at least a monthly check without, with all due respect, having to rely on the appointed 2 members or staffers. We have control as the 435 members of Congress to see that report and be able to exercise our duties on that. And I'll yield to the ranking member who had a question or a point.
Thank you. I just want to say, I think monthly reports are impractical. We want to rein in the FBI, not tie its hands with red tape. I worry this amendment would tip the scales away from practical